Okay, guys, we've finished up all the personal intentional torts, all the big 8 of them. We now have to do business intentional torts, and then we will go over some questions in the back of the packet of the study guide and answer those last 4 or 5 questions that we had from the very beginning, see how we do after whatnot. Okay, one thing I did talk about with the defamation of character of the doctor, remember if it's with malice, conditional or qualified doesn't work. We're going to get back to that a little bit later on in the business intentional torts from a business perspective rather than a personal tort perspective in a little while. Okay, let's go over business intentional torts on page 121, sorry, midway through your study guide on page 121. The first one is disparagement. It is also called product disparagement, and that's the way the old edition of the study guide a few years back, about 6 or 7 semesters back, called it product disparagement. The only reason I want to say that is if he didn't update some of his questions, they probably say product disparagement, which is the same thing as disparagement. If you look right after the word disparagement in your study guide, A says form of defamation. So if it is defamation on the personal side, on the business side is probably product disparagement or just disparagement in general. I just wanted you to know that. So if he asks you what personal intentional tort applies, you're looking for defamation of character probably, either slander or libel, depending on the situation. If he asks you what business intentional tort applies, it is disparagement. If he gives you a scenario and says what torts could apply, then you've got product disparagement or disparagement and defamation of character on the personal side as well. So you might have an A and a B, but not C, C and A, but not B, whatever. All right. If you look at the elements, it is an untrue statement, so it's a false statement about a plaintiff's product or property, so the other competitor's product or property. So say A plus and 4 Go were in a war, and they were talking back and forth. If 4 Go was to make some disparaging comments about A plus tutoring, and they were untrue, could A plus owners sue 4.0 Go for defamation, and vice versa? If A plus did the same thing for 4.0, could they sue for product disparagement, a form of defamation of character? Here's what's needed. It must be an untrue statement, just like defamation of character. It must be untrue about the person's product or property on a business setting. Then the defendant, i.e., the tortfeasor, must know that the statement was false. If they didn't know it was false, then, and they thought it was true, they may have little grounds for wiggle room for disparagement to get out of it. The statement is made with malice, meaning they intended to harm the other business. So if A plus makes a negative comment about 4 Go, that is false. Not necessarily true, but false statement. And it is done with malice, i.e. to hurt 4 Go's name, or vice versa with 4.0 Go doing it to say Tutor John or something like that. And the statement is made with malice. If they lose even one customer, that's what we call special damages. Special damages can be any kind of damages, but even the loss of one customer could do it. Okay, so let me get in, and the examples of slander of title, false statement about ownership of property, and slander of quality about the quality of the property made, also called trade libel. You might see the word trade libel on the exam. Just understand that's a product disparagement on quality. All right, I'm not too worried about the Texas elements associated to it on the bottom page 121. You can read those over. But one thing I want to talk about with product disparagement that really isn't located in the study guide anymore, but say I make a comment and I say, don't eat at Joe's Cafe. The chef's food is lousy. That's just my personal opinion about Joe's Cafe. Joe's Cafe may not like my decision or may not like my thing, but there really isn't much to do because it's not a form of defamation because it's my accurate opinion. It's a true statement in my eyes on my opinion. Now, if I make a statement more as a matter of fact, and it turns out to be false, then we have some issues. Let's say I say, don't eat at Joe's Cafe, the chef has AIDS, or with current situation, the chef has coronavirus. And now everybody doesn't want to go eat at Joe's Cafe and or doesn't want to order to go from Joe's Cafe, don't want to have anything to do with it because of the coronavirus, AIDS, whatever it is, okay? And what I said about Joe's Cafe and the chef is false. Then what can happen? Well, first of all, the chef could sue for defamation of character. It's a false statement, injuring the good name or reputation. And the third party heard it. It could be slander or libel, depending on how I did it. If I spoke it out, it's slander. So he could sue me for the personal intentional tort of defamation of character, libel, slander, depending on the situation, correct? Even per se, because if it gets to that point, if it's something that's more one of those big four that we talked about earlier. Now, it also hurt the business, Joe's Cafe. And if it in fact it is false, then Joe's Cafe would have argument for product disparagement. If even one customer decides, oh, coronavirus or AIDS, I don't want to go there and eat, won't get any to-go orders or anything, then they've lost one customer. That would be a form of product disparagement. So could you sue? Could the chef sue under personal intentional tort defamation? Yes. Could Joe's Cafe sue under the business intentional tort product disparagement? Yes. Would the business have to maybe prove malice? They have to show that malice was made. Yes. Does he have to show that malice was made as the chef? Not necessarily, unless he's a public figure. But even then, it's not going to. Even then, it's going to be much more difficult. It's probably going to be defamation of character. Okay. What is the difference between product disparagement and false advertising, which is on page 122 of your study guide? Is false advertising is basically saying, I'm making a false statement about my own product. Now, we've talked about the personal intentional torts, all 8 of them at the very beginning, and now we're into the business. What would false advertising closely resemble from the personal intentional torts for false advertising on the business side? And that would probably be what? It would probably be fraud. Remember, a misrepresentation, enticing someone to buy a product, they justifiably rely on it, and they get screwed over somehow, damaged, injury, harm occurs, they can sue for fraud. Well, that's kind of what false advertising does. You're making a false statement about your own product in hopes that someone will buy it. Okay? So if I make a false statement about someone else's product, my competitor's product disparagement. If I make a false statement about my own product, that would likely be false advertising. For instance, say I took this copy of the exam, SWIMS exam, exam 2, way back in 2000, I think that says 2009. If I was to tell everybody I'm going to have a special class to go over every single question of these in the packet, and I'm going to only charge, say, $5, $10 for each person, and then when that video or the live session happens and I don't go over any of those questions, then that is likely false advertising. I made a statement, you relied on it, it was later proven to be a false statement. I didn't do anything on that thing, I didn't go over any questions. If these were even SWIMS questions, maybe I made them up on my own. But you bought that believing something, that would be false advertising. Now, false advertising falls under the Lanham Act. The Lanham Act also deals with trademark law. That's at the end of Chapter 5 with intellectual property. So note the Lanham Act deals not only with trademark law, which is later on, but also false advertising claims. Now, in Chapter 7, you're also going to see that false advertising, deceptive advertising, and stuff like that is under the FTC Act also, which coordinates itself with the Sherman and Clayton Acts. That's Chapter 7. All right. The biggest business intentional tort is interference with contractual relations. It is the largest awarded tort victory in the history of the United States. It was like a $10 billion award between Texaco and Pennzoil. It was eventually settled for like $3 billion, but it was a the largest single awarded tort victory in the history of the United States. So if he asks you a question, which of the following is the largest tort awarded victory in the history of the United States, and he gives you options, one, you need to be looking for business intentional tort, and you need to be looking for the business intentional tort of interference. And then when we talk about interference, also interference with contractual relations, because there's another interference that we're going to go over later that doesn't really apply on that situation. Okay, so now interference with contractual relations. You have to have, once again, 3 criteria associated to it. You have to have 3. The first one is there must be a valid contract between the parties. Second, the third party, the one that causes all the problems, the tortfeasor in this case, must know that a contract exists between the 2 other parties. And the defendant's actions, the third party's actions, must entice one of those 2 parties to break the original contract, i.e. cause a breach of the contract to occur. and therefore damages or injures the other party to the contract. So, in this question, in interference with contractual relations, you need a valid contract between two parties. You need third party has to have knowledge that a contract exists. And the third party's actions, the tortfeasor's actions, must cause a breach of the contract between the original two parties. Now, let's make this into more of a personal side. That would be like, say, Jenny, okay, and Peter being married. Ted really wants to go out with Gina. He knows Gina's married, okay, to Peter. But he entices Gina to break off, divorce Peter. Maybe he says to Jenny that Peter has sex with goats, which may be true or false, depending on that. You have your own question with defamation of character, invasion of privacy, all that stuff. But if what he says is a valid contract between two parties, a third party must know the contract. Ted has to know that Jenny and Peter are in fact married. Jenny and Peter have to be married, and Ted has to know that Jenny and Peter are in fact married. If neither one of those exists, they're not in a contract, they're not married, and or Ted doesn't know they're married, then there wouldn't be interference. But if Ted knows that they're married, and then Ted's actions, saying that Peter has sex with goats, entices Jenny to get a divorce, then Peter could sue for interference with contractual relations. Now, I made that on a personal thing, and now we're going to play it to the business side. Change Jenny to Getty, change Peter to Pennzoil, and then change Ted to Texaco. Getty and Pennzoil had a contract. It was a valid contract in the eyes of the law. Texaco knew of the contract. In fact, they had told Getty that if something happens, we will indemnify you, pay you for your losses if you have a problem getting out of the contract. So Getty breached the contract with Pennzoil, and Pennzoil then sued for interference for Texaco. Texaco lost, largest awarded tort victory in the history of the United States for Pennzoil. So here's what happened. Getty and Pennzoil entered into a contract. The contract was breached by Getty to get out of it because of Texaco's actions, causing Pennzoil to sue Texaco for interference with contractual relations. Now, how could Texaco have gotten out of this? One, if they didn't know Getty and Pennzoil had a contract, if Texaco or Getty and Pennzoil didn't have a contract to begin with, or Texaco's actions didn't get Getty to breach the contract. If none of those had occurred, if all of those have to occur, if one of those had not occurred, then there was no interference with contractual relations. Now, here's where the tricky thing comes in. If he asks you a question about, in the Texaco versus Pennzoil case, which of the following occurred? And he goes, A, the tort for interference with contractual relations. B, a breach of contract. C, something else. And then A and B, but not C, or you know what? If it says which of the following occurred, interference with contractual relations occurred, but also a breach of a contract occurred. But if that same question was to say which of the following torts existed, instead of which of the following occurred, but which of the following torts existed. Tort of interference with contractual relations, yes, that's correct. Breach of a contract, if you remember going back to the original definition of a tort, it is a civil wrong other than breach of contract for which the law provides a remedy. So breach of a contract is not a tort. So if you pick A and B, you would be wrong the way the wording is. But in the first one, which of the following occurred in Texaco versus Pennzoil? Yes, a breach of a contract occurred. But the second question asks which torts occurred. And then it's just interference with contractual relations. Now, do not get this confused with interference with prospective economic advantage. And this is the last one in business intentional torts. In interference with prospective economic advantage, no contract between the parties is required. So Getty and Pennzoil wouldn't have had to have a contract, just maybe a working relationship, negotiations. And if Texaco realized they were in negotiations and wanted to give one or the other a better deal, they could. But then some states would say, oh, that's stealing customers during negotiations. We're not going to allow that. Here's the problem. It's okay if you don't have a contract, if you think about it. If you're in negotiations with one party and the other party gives you a better deal, why should you be have to deal with the first party when you can get a better deal with the second party. And a lot of people are saying that's why they don't recognize a tort. Many states, including Texas, do not recognize the interference with prospective economic advantage. Now, we do recognize interference with contractual relations, but Texas did not realize interference with prospective economic advantage. We don't recognize a tort. We realize that if you don't have a contract, then stealing customers during negotiations by just giving them a better deal, that's fine. Because remember, interference with contractual relations doesn't require any falsehoods, false statements, or anything like that. It just requires basically stealing a customer or a client while they're under contract. Okay? It doesn't say anything about false statements and stuff like that. So, but this is about where we're getting in for the red packet. But what I do want to say is we talk about Texas and what it does differently. Here are some things that you need to know specifically for Texas, in addition to maybe reading the study guide and reading the wording on each of the different acts, different types of personal intentional torts and the wording of those. But the things that you need to know: Texas is a gun-happy conservative state. So if it gives you a storyline like a blind man shooting a gun or an elderly lady shooting a gun, the juries are going to be much more sympathetic, especially if they're an older lady and they were accosted by someone stealing their purse or stealing their wallet if they're a blind man, stuff like that. So you need to recognize that. Secondly, we have what we call a castle law. And in the castle law in Texas, we don't have a duty to flee under criminal. Civil, not so much necessarily, but for criminal, we don't have a duty to flee. We can stand our ground, so to speak, and hold our castle. And that includes property in certain aspects, not all, but in certain property, along with persons, family, as well as you yourself. You don't have to use reasonable force. You can, in fact, use deadly force. If first used against you, you don't have a duty to flee, but that would all be under the Texas castle law. Then also under Texas, remember, infliction of mental distress was a tort we did not recognize until the Supreme Court did in 1993. Up until then, we were one of the last states to even recognize it. I think the 47th state to do so. And that was a Tidelands case. But remember, that is something right there that says we need to know that Texas recognized it late 1993. The other thing under defamation of character. Remember, defamation of character. If we defame a dead person's reputation, their reputation continues on even in the event of their death. In many states, once you die, your reputation is gone. There's no more, it's got to be a living reputation. Whereas in Texas, we say your reputation basically is perpetual. So if you defame someone's character with a false statement, remember, it's always got to be false for defamation of character to occur. If we make a false statement about someone who is dead in Texas, it could still equate to the defamation of character, whether it be slander spoken or libel written form. It could come into play. The last thing about Texas is, remember, interference with prospective economic advantage in the business intentional tort is not available in Texas law. We have interference with contractual relations, yes, but we do not have interference with prospective economic advantage. All right, this is where I usually end for this red packet. So what we're going to do is we're going to go over a couple of questions in the back of the study guide that are good ones. There's one that's kind of weird that I want to talk about, and a couple of these questions real quick, and then we're going to go over the 5 questions, and then we'll end it, and we'll start the purple packet with the next video. If you look on page 158 of your study guide, on page 158 of your study guide, we have a few sample questions that kind of go with some storyline scenarios. Now, I really think most of these are pretty easy. A couple of them are kind of used on the exam. They're just rewritten, or the multiple choice answers question is slightly different, which gives different multiple choice answers, or in fact, those multiple choice answers are moved around a little bit, but you have a couple of them. First one is question number 1 on page 158 of your study guide. Sam points a water pistol at Jane, who thinks Sam is going to kill her. Jane is terrified and runs away. Jane sues Sam. What will probably happen? The law would always rule for Sam since it was just a water pistol. No, if it's at night, she doesn't know it's a water pistol. If it looks real, then the fear is there for assault. The law would always rule for Jane since she was terrified. No, remember, reasonable person standard. If you can recognize it's really a water pistol and not a real pistol, then you're not going to always be terrified. You're going to use a reasonable person standard, so you're not going to have the always. Anytime you see always, it's probably not your best answer. So A and B wouldn't be good. If a judge or jury feels that the reasonable person would be afraid, then they would rule for J. Sounds good. If the judge or jury felt that it was unreasonable to be afraid of that particular water pistol, then they rule for Sam. And then C and D. The answer, if you look in the back on page 162 of the study guide, is E. Both C and D are correct. I can see a question similar to that, except probably a little bit more wordy on the exam. The next one is number 4 that's good. You're at a party and Herman gets very drunk. You try to take his keys away from him so he will not drive home drunk. To get the keys away from him, you hold him down and make him give you the keys by force. Sherman, however, is not hurt. Once he sobers up, Herman sues you for assault, battery, and false imprisonment. Which of the following is correct? Herman wins because you did those things. Herman cannot win under any circumstances because you have proper motives. Herman wins if you acted unreasonably. You win if the court finds you're privileged in your actions. C and D. If you go to question number 4 in the back of the study guide, the answer is E. 1, if you acted unreasonably, remember, unreasonable, you can't use unreasonable force. You can only use reasonable force to protect yourself or others. Taking some drunk driver's keys would probably fall into that criteria. So C is a good answer. You win if the court feels that you were privileged in your actions. If you were privileged, remember that's one of those things that under assault and battery privilege. Now, privilege is usually reserved to the police, but if you are privileged in your action, that's what the answer gives you as a possibility, then that would be correct as well. That's why the answer is E. All right, another one is number 10. Howard and his girlfriend decide to drive through a crowd in a nude on his motorcycle to attend a streak-in. At the academic building, the motorcycle dies and he has to jumpstart the motorcycle on the stands while she stands next to him trying to describe what to cover up. The student newspaper takes a picture and publishes the next edition of the paper and names Howard and his girlfriend. If Howard and his girlfriend sue, what is a probable tort and result? Is this an invasion of privacy? No, it's not an invasion of privacy because they did this in the public. You didn't have a reasonable expectation of having a private setting, so they would not win. It's an invasion of privacy, but they would lose. Sounds good. Defamation, they would win. There's no defamation here, period, even though it was put in the paper. There's no false statement there. So defamation, they would win. Defamation, they would lose. Defamation really doesn't apply. So if you look back, the answer number 10 on page 121 is B, invasion of privacy, but they would lose. It wouldn't apply to them because they didn't have a reasonable expectation of privacy. Now, number 15 is the one, we're going to do 2 more, but number 15 is the one that he has various different ways of going through this. A student body president at a major university goes to the party and gets drunk. He then tells all the attendees at the party that a very popular basketball coach is really a child molester. He was at a meeting where the president of the university has decided to fire the coach. One of the party goers is the editor of the newspaper and makes this the headline story in the next edition of the paper. The basketball coach sues for defamation per se. What must he prove to win? The statements have to be false. That is correct. That this harm is so bad that he would not have to prove harm. Well, that's what defamation per se is all about. It's so bad. It's one of those 4 criteria that's so bad that you don't have to prove that it would injure your good name or reputation. Now, I don't like the way answer B is phrased, but that's true. That the supposed defamation was actually published. He needs to prove all of those. Does he not? If you look at number 15 in the back of the study guide, all of the above. If they're going to sue, they got to know that it was published so the third party has knowledge of it. Now, what if he changes that question and says, if he wants to sue the party goer for saying those statements and they were in fact false, that would be defamation of character. And if it was at a party, that would be slanderous, correct? If you wanted to sue the newspaper or the editor of the newspaper for writing the story and it was in fact false, then that would be defamation. That would be defamation of character via libel because it's the written form. Now, how did they find out he was a convicted child molester? Or, is really a child molester? If he has photos that were in his file cabinet, that's how they found out that he was a child molester, because he has pictures with children, then yes, it is not defamation, and it's going to injure his good name and reputation, but it's not false, so no defamation, but it could be invasion of privacy because we didn't have a right to take those pictures without their permission. All right, so be ready for number 15 in different forms. Number 19 is interesting because number 19, the semester before, the answer was a different choice. And now, according to the new study guide that you got this semester, it is a different answer, but the question has not changed at all. Mary thinks that Sterling is the best looking guy in school. Mary asks Sterling out and he rejects her. She finds out that Sterling is gay and dances at a gay bar. Mary tells the whole class at the next meeting. Sterling sues Mary for defamation and invasion of privacy. Sterling will win both cases if he can prove he suffered damages, win if people in the class heard the accusation is in fact true, lose the defamation case if he is gay and dances at the alleged club, but win the invasion of privacy case if there was a disclosure of the private facts, lose the defamation case if he is gay, and lose the invasion of privacy case since he dances in public at a gay bar and who cares if he's gay, there's insufficient information. Well, he wouldn't win both cases because if he is gay, it's not defamation. Win if people in the class heard the accusation and the accusation is in fact true. That wouldn't apply either because if it's true, it's not defamation. So A and B aren't correct. We're going to be down to basically C and D because I think E, there's enough information to answer. C, lose the defamation case, in fact, if he is gay. That is true. And win the invasion of privacy case if there is a disclosure of private facts. That portion is also true. Lose the defamation case on D, in fact, he was gay. That's true. But lose the invasion of privacy case since he dances in public at a gay bar and who cares if he's gay. Well, the answer used to be C. This semester, if you look at the back of the study guide, the answer is D. Now, whenever you reverse engineer a question like this to find out why the answer is stuff if you can't figure it out on your own, C makes a lot of sense, but D also somewhat. And then now you're at the mercy of which one does Swim think is correct. Well, last semester in the study guide, the answer was C. This semester, the study guide answer is D. It's the exact same question. So it's kind of crappy that you can think one way and then the other way. For it to be C, here's the thing. We lose a defamation case if in fact he is gay. That's because he wouldn't be able to win a defamation case because it's true. But if he dances at an alleged club, but he wins the invasion of privacy case, there's a disclosure of private facts. Just because you dance at a gay bar doesn't mean that you're gay. I mean, you could be, but it doesn't mean that you are. So how is there disclosure of private facts that he is in fact gay? If that was a private disclosure, a public disclosure of private facts, then that could arise to invasion of privacy, and that's why C could have been correct, and that's why it was maybe last semester. But then you look at D, losing defamation case, and in fact he is gay, yes, and lose the invasion of privacy case since he dances in public at a gay bar, and who cares if is he gay? If the invasion of privacy case, there's no invasion of privacy once he is in the club, but that doesn't necessarily mean that he's gay. That's why C was the better answer in my opinion in the past. But we're going to go with Swim. And if Swim thinks it's D based upon the relevant information, we go with D. I had no problem with C. I thought that was a better answer. I still think it's the better answer. But once again, it was changed this semester. There was a legitimate reason to change it for whatever reason it is. And that makes D the correct answer currently. If you have any questions, feel free to email me. But let's go over a couple more questions from the very beginning of the red packet. I wanted to go over at least two more. I like number 7. In which of the following situations could Robin successfully defend herself in a fraud case if Lily was to sue her under tort law? So Robin is a tortfeasor. A, Robin believed the product she told Lily worked as intended, even if it did not work. That would be a successful defense because she thought it worked. You got to have knowledge that it doesn't work. She didn't have that. Robin didn't believe in the product worked, as she said in her statements, but the product actually worked as described. Well, if it works as described, it's not a misrepresentation because it actually works. So element number 1 isn't there, and you got to have all 5 elements. So A, number 2 element is not there, no fraud, Robin can defend herself. B, element 1 is missing, no fraud, Robin can defend herself. Robin says nothing as to avoid a false statement when asked by Lily if there's any problems associated with the car. Robin is trying to sell her, even though she knows the information would be pertinent to Lily to make a decision on purchase. That would be that misrepresentation through omission. She would not be eligible to defend herself from fraud like her. Lily knows Robin lied about the product, but buys it anyway from her, and then days later wants her money back for fraud. Well, if that's the case, then Lily didn't justifiably rely upon it, meaning element 4 is missing. Therefore, A, B, and D are all ways that Robin can defend herself. And so the answer to number 7 would be E. All right. Let's do number 10, last one. Robin is at a college drinking party, tells everyone that she read Barney's diary and he is bisexual. If he is in fact bisexual, then what, if anything, could Barney sue under tort law? Defamation via slander, defamation via libel, defamation per se, invasion of privacy, both A and D, but not B or C. Well, it can't be any defamation because it's true. Whether it's libel or slander, irrelevant. It's not defamation because if it is in fact true. So A, B, and C do not apply at all. Could it be invasion of privacy? Yes, it could be invasion of privacy. So which ones could she actually sue under tort law and win? Then the answer is D. Technically, I guess he could sue for all of them, but he would only win possibly D. He would not win A, B, and C. So answer number 10 is D. Okay, if you have any questions, please email me. The next video in the line will be on the purple packet, and we'll discuss that on the next video. Thank you.